Thank you all for attending today's session on effective and ethical governance. This is part of the required training for all regents and trustees that they have to take within their first year of service pursuant to 61.084 of the Education Code. My name is Doug Brock. I'm Assistant General Counsel at Texas Higher Education Coordinating Board, and I'll be moderating this panel today. I'm very much delighted to introduce this talented, experienced, and dedicated team of attorneys to you today. Immediately to my left is Augustine Rivera Jr. He is General Counsel for Del Mar Community College. Next to him is Nella Herrera. She is the Vice Chancellor and General Counsel at Texas State University for the Texas State University system. My apologies. And finally is Jeff Parks. He is Deputy General Counsel for the University of Houston. We have a jam-packed session for today, so don't want to spend a lot of time with introductions. The only thing I have to add is that the information we provide for you today is not legal advice. We're going to share information, but if you have any legal questions, you are highly advised to go talk to your legal counsel. Once again, this is not legal advice, even though we are attorneys. So I want to start. My first question for the panel is I have a series of questions we're going to go through, have some hypotheticals, and then we're hoping to reserve some time at the end for questions. So if you have any questions, just take note, and we'll try to get those to at the end. The first question, Regent trustees serve in a fiduciary role. Fiduciary comes from the Latin term fiduciaris, meaning to entrust or hold in trust. It wouldn't be a training with lawyers if somebody didn't toss out some Latin phrases. So there you go. As a fiduciary, board members owe certain duties to their institutions, including care, loyalty, and obedience to help ensure the member is acting in the best interest of another party. Would y'all be able to give board members, a brief overview or examples of these duties? First, I'd like to start with Nellie and the duty of care.
Thank you, Doug. And thank you all for being here. It is such a pleasure to be able to do this presentation with you because it does give us an opportunity to remind regents and trustees about your fiduciary duties, the most important obligations and responsibilities that you all have. The duty of care is one that is so straightforward. I love talking about it because it's super simple, and I like simple stuff. So the first thing you need to know is about a duty of care. The way you are performing your duty of care is by being informed and by being informed and knowledgeable about matters that are going to be presented to you at the board. Now, how do you become informed and knowledgeable about matters? That doesn't require you to be subject matter experts on anything. The good thing about your positions is that you have access to people who are subject matter experts. You can rely on your general counsels. You can rely on your auditors. You can rely on your CFOs. Those are the subject matter experts who are going to present items to you for your consideration. What you need to do is some of the most basic things. For example, you need to attend meetings. You need to review the board materials when they're presented to you so that you will be able to participate in the discussions that will occur. That's how you become informed. That's how you become knowledgeable about the matters that are coming before you. That's your duty of care. Because at the end of the day, the way that someone will determine did this trustee or board member exercise their duty of care, they're going to say, did this person do what a reasonable person would have done under the same or similar circumstances? Not whether or not you were able to spot every issue in a matter or whether you knew every item in a document that they were giving you. No, you're going to be judged by that standard. Did you do what a reasonable person would have done? And in this case, it's just a matter of you being informed of what is being presented to you. And that's in a nutshell. That's pretty quick.
Thank you. Augie, would you like to take on duty of loyalty?
Be happy to, Doug. And I want to second and echo what Nellie said. Thank you all for being here. She kind of stole my thunder already because at some point we're going to talk about takeaways, and it begins here and continues on with what you do. Staying informed, staying educated, and being on top of things is how you can fulfill your duties as a trustee or regent. And let me also say thank you for your service. One of my regents, I got to give him a shout out, Bill Kelly from Del Mar College is here, and I appreciate what he and the other regents do as well as what you all do. These duties that we're talking about, so Nellie just talked to you about the duty of care, the duty of loyalty. It also sounds simple, but I'm not disagreeing with my dear friend, but they sound simple, but they can be very complicated. They can be very complicated concepts to recognize, first of all, when you're out in the real world. And secondly, how do you deal with it? How do you tease it out? How do you, my favorite thing is I Rubik's Cube stuff all the time. And it can get really complicated. That shouldn't be a daunting thing or take you away from it. Instead, that's when you should go to it to try to figure it out. Follow your instincts. If you think something feels like a conflict or not exactly right, go ask somebody about it. And Nellie already gave you a laundry list of who to look to. The duty of loyalty, again, the simple and clear definition, the duty of loyalty also obligates board members to act in good faith and to put the interests of the institution they serve above their own personal or private interests. Fiduciaries must avoid conflicts of interest and make decisions that are best for the institution and not for individual gain. Again, that's simple to understand, and every one of you is sitting there saying, I know exactly what that means, and I will never, ever put my interests above the institutions. You don't know it until you see it and until it's in front of you, and then you got to deal with it. So you should enforce conflict of interest. First of all, you should have conflicts of interest policies. So how many of you are brand new trustees or regents? I always like to ask that. All right, here we go. How many of you read your bylaws and code of ethics already? Okay, all right. So for those that don't, that's okay. You still have time. That's homework for you to do. How many of you are familiar with what the conflicts of interests laws and policies are that apply to you? Yeah, exactly. So you know, it's okay. It's a work in progress always. But so know where your conflicts of interest policies are. Become familiar with them. Preserve things like confidentiality. Promote transparency through everything you do, through the by meeting in an Open Meeting Act, in compliance with the Open Meetings Act, and establish policies for whistleblowing protection. What do you do if you see something that's not going right? And carry out your duties with integrity and honesty. And I'll leave it there. The duty of loyalty means that you put the interests of the institution above your own. You never use it for personal gain, and you carry out your duties with integrity and honesty.
Thank you, Augie. And Jeff, would you take a few minutes to discuss the concept of duty of obedience?
Sure. So duty of obedience, that's basically ensuring that your board, the university and the college is operating in accordance with its mission, its stated purpose, and also in compliance with the law. So like Augie was talking about, reading your bylaws, making sure you understand what those are. You'll have board policies, making sure what those are. And the great thing is you can rely on other people, right? So your council, whether or not they be dedicated to you or not, they're the ones that are going to help you comply with the law. Your bylaws, everything's been set up already in accordance with the law, but then if you have questions, you can go to your council.
Thank you, Jeff. This whole concept of care, loyalty, obedience will be reiterated throughout the questions we hear today. And it's also important to keep in mind that, this is a unique form of governorship, whether you're, at a community college or at a four-year institution where you are there not to serve yourself, but you're to work as a team and put something greater than yourself at the forefront. And that's what a lot of this comes back to. So to that end, there are a lot of state laws that play within these fiduciary responsibilities. Ms. Herrera, there are certain components in the Education Code and Local Government Code that set out requirements for an institution that wishes to contract or transact business with a business in which a board member may have an interest. First, is that prohibited?
Well, I'm going to tell you the answer from my perspective, and I think then my colleague is going to also provide some additional information for institutions that are different from the ones I represent. From my perspective, I work at for institutions that have four-year institutions, and so we also have some that have there are two-year institutions. For my institutions, if somebody had that situation come up, what they would have to do, our regent would have to in open session during a board meeting, not an executive session, not in a closed meeting, but in an open meeting, they would have to disclose their interest in the business. So if an institution is trying to contract with a business and they own a part of that business, they're not prohibited from, the institution is not prohibited from contracting. It's just that the regent will have to, in open session, disclose that. And then the region will be obviously precluded from voting. They will not be able to vote on that contract. It's pretty straightforward. It's guided by a state statute. And it's sometimes, I think it's great to have a state statute because you can read the statute and apply it. So in this case, yes, you can do it, but you have to make the disclosure and you cannot vote on the contract. But Augie, you have some more of that. Add to that.
So how many community college trustee regents here? Where are my people? There we go. All right. Thank you all for being here. I love community colleges, all 50 of them in the state. You guys do an outstanding job. You punch way above your weight, and we don't have the means sometimes of the university systems, all right? But we're getting there with HB 8. It's going to be an interesting and challenging year. I'm excited about where we're going. But you also have conflicts of interest that you have to abide by. The process that Ms. Herrera just talked about is basically the one that you would have to follow if you discover that you have a conflict. You would have to disclose it, file a statement with the appropriate office at your college, and then not participate in the discussion or the decision making with respect to a contract in which you have, or any other decision, frankly, that in which you had a conflict. But there's a state statute in the education code, but you all, by virtue of your status as local government officials, would be subject to Chapter 176 of the Local Government Code, which requires you to report conflicts of interest that you have with vendors or potential vendors of the local governmental entities. You'll have to file a conflicts disclosure statement, and there's a form that's put out by the Texas Ethics Commission. The vendor would also have to likewise file a disclosure statement. And I could go through the details. It's similar to the one that state officials are subject to, but they actually have different values. There are different monetary values that differentiate the two. But basically, if you've got an employment or some other type of business relationship, or a family member, the rules of consanguinity, right, which go out to even near relations. Anyone who had a relationship like that, you would also, potentially subject you to the conflict. So it's 176. I would advise you to go talk to your general counsel or to the lawyer for your institution if you've got a conflict. And as soon as it comes up, as Nellie said, you'd have to bring it up as soon as it comes up.
Thank you. So when we get to the business transactions, that kind of side, it's more of a checklist. It's more black and white. There are certain parameters that if you meet them, then there's disclosure requirements. Where it gets more tricky and nuanced is where there may be a personal interest at play, and that poses a conflict of interest with your duties as a board member. And so, Jeff, I'll start with you. What advice can you give to the board members about identifying where there may be a conflict of interest? And what steps should a board member take in the event of such a personal conflict?
Yeah, I mean, first of all, if you find yourself thinking, to yourself, hey, I might have a personal conflict of interest here, I would tell you at that point, it might be the point where you need to stop and step back and think about it, right? Because if you're trying to do it more than a few minutes or, there probably is something there. And I mention that because, right, it's not just if there's a conflict of interest, it's an appearance of a conflict of interest, right? And so if you're struggling with it, odds are someone else is going to struggle with it too and think, well, why'd they do this? Or why, I think they had a conflict. And you really don't want to get into having to defend yourself based on a conflict of interest. Like Nellie was saying, it's no different than with contracts, right? You'll basically disclose the conflict and recuse yourself from it. Depending on the nature of the conflict, you may not even want to be involved at all. When I say that, you might want to step out of that board meeting. You might, so that no one can even say, hey, you were there. You might say, well, I'm going to step out for this portion of it. But really, it's, the conflicts of interest, some are going to be like black and white, no doubt. You have a financial interest, you own a company, whatever, you have relatives, but there's other ones that are going to be very nuanced. And so just, think to yourself first, is there a conflict? Then try to think to yourself, well, is there any way that someone might think I have a conflict? And then, right? Oh, well, I have a cousin who works in this business. Yeah, well, maybe even though it's somewhat unrelated, you might want to be like, well, just think about it a second. And then also I find it's a good thing to collaborate. You can collaborate with other board members and regents, or also with council and tell your council, hey, I have this situation. We have it happen all the time. The council, board member will come and say, hey, what do you think, what should I do here? This is what the situation is. This is what I'm worried about. Can you help me?
Thank you. Augie, is there anything you'd like to add there?
Yeah, so some of our community colleges have come from smaller communities, right? We're not in Austin
That's a good point.
or Houston or Dallas, the Metroplex, where, yeah, I may know someone and they're really good friends of mine, and so maybe I should step out. It's not going to be a big deal. When you come from small towns, the potential for conflicts just goes up. Just believe me, I come from a very small town. And so I'm not saying anything different from what Jeff said. I think you need to tread cautiously and look at it seriously. But sometimes, the appearance of impropriety is one of those, maybe it's not legal, but it's more ethical. And you're just going to have to figure that out on your, for yourself, and what fits best for you and what makes you comfortable. But I agree 100% with Jeff. And in addition to the resources that you have, your general counsel, your chancellor, president, look to your fellow board members and air it out with them. If it's something that's a personal conflict and where it would not look good, but that may just be a function of where you're at. That's the only thing I'd add.
Thank you. Nellie?
The one thing I want to make sure that you all remember and keep in mind is that you as trustees or regents, you are part of a policy-making body. You're not part of a manager body. You aren't there to operate, right? You're not the managers of institutions. You are the policymakers of institutions. I ask you to keep that in mind, because when somebody approaches you and says something like, hey, can you help me with a resume? Can you, with a admittance into some program? Can you help me with this issue? Think of for a minute, are you being asked to operate and to look at this at a policy level, or is it something more of an operational level? Because quite frankly, if somebody's asking you, hey, I'd like a letter or resume for my kid who don't know anything about, but trust me, great kid, and I want to get him into your school, are you really being asked to operate at that policy level function, right? You're not. You're being asked at a different level, and it's when you get to that different level where there's more of an opportunity for you to have a conflict here, for there to be a outward appearance of a conflict and an actual conflict. So just keep in mind in what capacity you're being asked to do things.
Can I just
Yes.
That's a very important point, because, so for example, in the area of gifts, I think you all pretty much have a general sense that you're not supposed to be accepting gifts, and if you do, and they're above a certain amount, $100, I think, then you have to report that, right? You have to put that out there. There's an exemption from that, and that's if someone is truly a lifelong friend, or very, very close acquaintance that you've known for a while. There's some gray lines in there. Do what you think is right, but the fact of the matter is, it's not always black and white, clear as day. Okay, I'm going to do this or that.
It's a good point. There's been some recent examples of that in national media on, well, where does the conflict of interest lie? Even with our Supreme Court justice. This is something everybody has to grapple with. And so really that first step is being able to identify where there may be a potential conflict of interest, right? Now, the next part is trying to figure out, well, how do we as legal counsel help advise board members on how to respond and act where there has been identified conflict of interest? Because honestly, easiest part is identifying where there is one. Responding, it can be very difficult. As Augie mentioned, in your communities, you're going to have pressure put on you of, hey, I know you're on the board and I have this issue. Can you help me out? you'll be on the spot. I mean, my general advice is always like, now is the time to develop your elevator speech because like when you're in that emotional situation, you're going to be stressed. You're going to be like, I know this person or this person voted for me and they were instrumental in me getting this position. How do I respond? Well, in that moment, it's not the best time to react. It's having a plan ahead of time. So I want to open this up. What advice do you all give board members when they've identified a potential conflict of interest and navigating that? And I'll start with Jet, if you want to go first.
Yeah, I might just start with one other point. Be mindful, just by the very nature of your position, whether or not you be trustee or a board member, that alone has power and authority. And so when you do things, you have to be mindful just because you may think nothing of it. Like, hey, I know someone, they want to work here. I know people who do the hiring, but I don't care. I just want to get him the right people. So I'm going to help put that in front of this person, right? And say, hey, here's someone I know who would like to interview for a job. And you're thinking, oh, all I'm doing is helping this person get to the right person so they can schedule an interview. I'm nothing more. But the person that you've approached might see it differently, right? They might be like, oh, wait a minute. This is a board member or trustee. They didn't really say it, but I think they want me to hire them. I think I have to hire them because it came through them. So just be mindful that just by the very nature of your title, position, you have a lot of authority and power, and people are going to take it differently than just a normal person asking for something. It's very nuanced. I'm sure we all deal with it too. I mean, for instance, I have a gym membership at our university, and the gym was closed for a couple weeks, and they didn't reimburse any money or do anything. I didn't really think that was right, but I didn't say anything or do anything because me saying something to those folks because of my position would mean either they'd think, hey, by the law, we need to reimburse these people, or hey, Jeff's telling us, we need to reimburse people, so we're going to reimburse people. So you just have to keep that in mind.
Nelly?
I love that, what you just said, Jeff, because to follow up on that, I'm gonna give you all something here. I'm gonna kind of date myself, but I'm okay with that. So a long time ago, there used to be a commercial on TV, and it was for an investment firm. The investment firm was called E.F. Hutton. All right, some of you may remember the logo, the slogan for this whole commercial was, when E.F. Hutton talks, people listen. When you as regents or trustees talk, people listen. So that introduction that Jeff talked about all of a sudden takes on a whole new level. This is a regent asking me to interview somebody. That's way more important than this is little Nellie asking me to interview somebody. Or you're at a totally different level with the power and authority that comes with your position. And so when I do these presentations to regents, I hope to remind them by telling them about that commercial. When you speak, people listen.
Okay.
Yeah, so one of the simple rules that I preach to my board is stay in your lane. Figure out what your lane is as a trustee or regent and stay in it. And hiring is not in your lane, except with respect to your president or chancellor. And that's it. Supervision of other employees at your institution is not in your lane. That's up to others. You supervise one employee, the president or chancellor of your institution. So that's how I frame it. That's how I say it time and again. Stay in your lane and you should be okay. Now, the elevator speech, I know this because I've been told this by my regents that, there's a big contract coming up and folks call and they want to talk to them. Just informational. We're not trying to influence you or anything. We just want to make sure that we answer all your questions. I personally think that that's up to each of you to decide individually with how much you can tolerate. If you really truly think that you can listen and not be influenced or be swayed, more power to you. I don't want to get in your way because ultimately for community college trustees and regents, you're elected officials. And I always acknowledge that and I respect that. I say you've got to be accountable and available to the community. That's the nature of the job. But if you don't want to do that, and you don't consider that to be in your lane, then that's what you say. You say, I'm sorry, we have a process, and at Del Mar College, we actually have built into our code of ethics that during an active procurement process that all requests for information and communication shall be channeled through the board chair and the college president. And that kind of lets the world know that I'm in this lane and that's not it.
Thank you.
Yep.
And going into that kind of staying in lanes, we're going to talk a little bit about access to student records. And I'm going to make an assumption I believe is probably correct, is that y'all are serving for the betterment of students. That's why we do what we do. I mean, that's why I know everybody on this panel works for educational institutions, is we want to benefit the educational systems that benefit our students. And so with that comes potential access to student records and personally identifiable information. But there are some very strong federal laws on the books regarding access to personally identifiable information. For us, the two main ones are the Family Education Rights and Privacy Act, which is the acronyms used FERPA, which actually has two components. Like, I mean, if you want to get in the weeds on it, the original purpose of it was to ensure parents could get access to their students' education records. It also has a major privacy component that those records are confidential and private. The other one is the Higher Education Act. So I wanted to the panel, I'll start with Jeff. Can you describe advice you give or training you recommend to board members, trustees, or other high-level administrators on what they need to understand about limitations and exceptions to FERPA, HIA, and access to education records?
Yeah, so when you start dealing with a student's educational record, your antenna should go up. You should be thinking privacy, confidentiality, and what's happening with regard to disclosure. And so there's really two key pieces to it, right? One is what's an educational record. So I'm just going to read the definition. FERPA defines it as records, files, documents, or other materials that are maintained by an educational agency or institution or by a person acting for such agency or institution. And so it's going to include things like GPAs, grades, social security numbers, academic evaluations. So that is an academic record, education record. Now, what is a student? Okay, a student is one who has enrolled in your college or university and has attended a course. So if they apply and they don't get in and they never attend that course, then their records are not subject to FERPA, meaning they could get disclosed. Now, what's so big about FERPA? As they mentioned, one, there's a lot of penalties to it. I'm going to get to it in a second. But there's also some exceptions to it. And for you, so first of all, we're not expecting you to be legal experts by any means. To this day, when FERPA questions come to me, I'm pulling out books, I'm looking through the statute. It's a very nuanced area of the law. But one, put your antenna up if you hear, hey, educational records, and you start looking to disclose them. And then two, think about, there's one exception, there's multiple exceptions, but the one that is probably going to be used by you all is legitimate educational interest. So you can get disclosed with other university employees and also certain outside agents if there's a legitimate educational interest. And so it's a fairly big exception, but just be mindful. And let me talk real quick about the penalties, because really that's the key takeaway. Student records, confidential, don't disclose unless you have some sort of exception. And the penalties, so they start to the top, loss of federal funding. So if your institution takes federal funds, and most do, then that's a big possible issue. You have legal action where both the university and the individual could get sued. And then the person who disclosed it could be subject to discipline too, up to termination. So, and also you're going to probably be dealing with the Department of Education, and you really don't want to be talking to those folks, not on a daily basis. And then also there's potential criminal charges too. So just think bad stuff, FERPA, disclosure, bad. And it'll get you pretty there. Go ahead.
Jeff, has any institution ever lost federal funding for a FERPA violation?
I don't think so. And I'll
Want to
tell.
be the first.
Yeah, exactly.
Yeah, and I'll tell you. I mean, this is getting recorded, so hopefully no one at the Department of Education sees it. But and during the course of my practice, most of the time things can get worked out, right? Because it's an inadvertent disclosure, and you go and fix it. Sometimes there's going to be remedial training, there'll be some sort of notification, but a lot of times it doesn't reach, the big stick of loss of federal funding. But I'll tell you, I mean, I think it's possible if you just completely have like a gross negligence or blatant disregard, and it's bad, and there's a ton of students involved, then maybe. But yeah, I mean, there is no loss of federal funding.
Yeah.
Not yet.
Yeah, not yet.
yeah.
Not yet.
Does anybody have anything they want to add to that? You're good with
Jeff
moving on?
covered it.
Great. So, speaking of students, activism and protests. They've actually been part of the historical fabric of higher education dating back to the 1500s internationally. In the United States, best we can tell, probably 1766 with the Harvard Butter Rebellion. If you want to Google something later, I recommend looking that one up. Now, it really wasn't until 1961 with the Supreme Court decision in Dixon v. Alabama that there was a change. So prior to that case, colleges were really able to substantially limit student constitutional rights under the in loco parentis policy. Basically, they stood in place of the parents. They could discipline, take action against students for minor infractions. That case changed that policy and put constitutional protections in place for our students in college. So now that these students have these rights, institution policies must respond to student activism under a First Amendment analysis. I'll go back to Mr. Palmer. What should board members consider in regard to policies pertaining to campus disruption in light of First Amendment protections?
Yeah, again, it's a very nuanced area, and we're seeing an uptick at the University of Houston where I'm at. We've had multiple protests. It seems like we have a protest every day, and we have protests for every board meeting. And so to keep in mind, I mean, one, we have a freedom of expression policy, so your institution hopefully will have that. If they don't, just be mindful, right? You can have reasonable restrictions on manner, place, means for the speech. Also be mindful, hate speech is protected. I mean, a lot of people may not realize that, but it is. I mean, hate speech is protected, so keep that in mind, because you're going to have people who come to you and say, hey, we need to shut this down. We need to stop this. And the truth of the matter is they're probably protected under the First Amendment. I mean, the First Amendment was not protected, right? You're going to have defamatory statements, you're going to have obscenity, and you're going to have the fighting words where basically incite violence. But most of the protests we see on our campus, it's none of that, right? It's just they're doing things that people don't like. For instance, at our last board meeting, they were shouting at the board members, saying that they were complicit in genocide, yelling at them personally, put out some wanted pictures of our chairman and of our president. And so just be mindful that, so what do we do? So we allow them to protest in a peaceful manner, right? We find a place. So during this last board meeting, we worked with a police department, and we basically segregated. We had a place where they could peacefully protest. It was right in front of the building, which they liked because they could shout at people coming in and out of the board meeting. We had an overflow room where they could go and watch the board meeting too if they weren't able to get into the actual board meeting. And then they went there, and it was fine. We also have open session, like, right, part of the board meeting, you're going to have open session. So our folks keep registering for open session, and which is their right. And so what we've done is we used to get 5 minutes per person. We've cut that down now to 2 minutes per person, just because, it's a reasonable restriction. And so they go and do that. And this last time, just to give you a flavor of it, I mean, they were like naming off names, I guess, of folks who had died during the Gaza war and saying that our board members were responsible for those deaths and Hope State haunts them to their grave. So after that, they basically disrupted the board meeting, which they're not allowed to do, right? So you're talking about First Amendment, right? There's some restrictions, right? You can't substantially disrupt. That's one. You can have that as a means. We do. And so, well, what we do, we let them do it for a couple minutes, right? You let them, because if you roll in the police and then arrest them all, that's just going to escalate things. So we let them go ahead and do their thing for a couple minutes, and then we had the police officers tell them, hey, you need to leave. And if you don't, we are going to have to arrest you. And then they went outside, outside into kind of an auditorium area, and still yelled, which you're not allowed to do. 'Cause at least in our policy, you're not allowed to protest indoors. But they kept doing that, so we did the same thing, let them do that for a couple minutes, and then escorted them, told them, hey, you need to leave. And eventually they got to the place where we had designated for them. But yeah, one thing I will tell you above all, again, remember nothing else, if you're going to restrict free speech, talk to an attorney. Before you take that step, no matter how bad it might seem, talk to the attorney quickly to say, hey, this is the assessment. So at the board meetings, I work with our chief of police. I'm there to basically provide real-time advice to him if we have to go the step of shutting things down, arresting people, arresting students. But if you don't have a police officer, that's okay. Just think to yourself, if you're getting ready to shut down something, reach out.
Thank you, Jeff. Nellie, what would you like to add in terms of developing the policies and then also the real-time implementation of them? Because you can have the best policies in the world, but when it comes to something that happens organically or immediately, it's like, how do you make sure that those policies are correctly implemented in real time?
Absolutely. And everything Jeff said, I agree with. And what I loved that he did was explain to you the process that they do, what they did when things start to escalate. Because without having talked to Jeff, I bet they already had all that in place. They had a plan in place. And so you as trustees and regents, what I would recommend to you all is when you have an opportunity to visit with your general counsel, these are the types of questions that maybe you want to know about. When you're conducting your board meetings, if there's a disruption, if there's a protest, if there's an instantaneous protest or a planned protest, how are you supposed to react? How should you react? And it would be important, if I were a regent or a trustee, to find out from my general counsel, is there real-time response to this? Because that real-time response, in this day and age, it's critical. Because without that, as you just said, Doug, you can have the best policy in the world, but if you don't have some type of real-time response, it is not going to go well for you. One of the things I absolutely love about one of our institutions is they have put together a team, and this is not what they call it, but this is what I would call it. It's a rapid response team. When a protest breaks out, either a planned protest or a spontaneous protest, there are certain stakeholders that are brought together immediately who jump on a Zoom or jump on a call to talk about what happened, what's going on, and how are they going to respond to it. And everything is different. All the planning in the world will be wonderful, but the problem is you can't plan for every contingency. You can just do the best you can, and the best you can is if you have people immediately to address that particular situation. I'll give you an example. We had a protest on one of our campuses. It was a planned protest. The stakeholders from our different departments, and one of the departments was UPD, another one was student affairs or student government. These people were all brought together to talk about this planned protest. The planned protest went exactly like we had anticipated. They were allowed to protest. They complied with our policy on how to do it. They even cleaned up after the protest. Whatever litter was on the floor, they picked it up. They were great. We loved it. Then we had a spontaneous protest. But let me tell you about the spontaneous protest. That first planned protest took a lot of people, had to bring a lot of people together. We had a physical presence there. Unobtrusive. We were allowing it to happen, but we had people there on the spot. For the spontaneous protest, we had two different ones, and they happened on the same day. One of them was one student who decided they wanted to go and hold up a flag. Just one student holding up a flag, and that even though it was a spontaneous protest. So it did trigger the rapid response team, but the rapid response team said, whoa, whoa, whoa. We do not need this kind of expansive response for this one protester. But in real time, they assessed it and they all took care of it. It took maybe 4 minutes, right? It did not take a lot of time. The other spontaneous protest that happened the same day took a little bit more time. Group had to come together again and address that situation, because that situation involved many more people. It involved a march. It involved more. And so again, the rapid response team was able to get all the stakeholders, UPD, student affairs, dean of students, everybody. They came up with how they were going to respond to this spontaneous protest. What were they going to do with the march? And it was great, because they were in real time, were able to talk it through. So you all, as regents and trustees, the conversation I'd have with GC about protests is ask them, what kind of response do you have? I love the policies, great. What kind of response do you have when these things break out and they're spontaneous?
Thank you. Now, Augie, oftentimes these things can come into board meetings, whether it's open, public comment or attempted disruptions to a board meeting. What do you think board members should be mindful of, and what advice would you give them about, public comment and disruption of board meetings?
Yeah, I think Jeff covered that kind of
Pretty
already.
much, yeah, a little bit,
pretty
yeah.
much. But I would add this: at Del Mar College, we have security at every board meeting. It's just our chief of police is there all the time, prepared, whether we're anticipating a protest or not. Thankfully, it doesn't come up. But that's one additional practice tip that I would give you. If I could
Yeah, of course.
pick up a couple things, because I had the opportunity this summer to speak at a national higher ed lawyer conference. I was in a panel with some lawyers from California, and of course the protests were going all. So it was a great panel. But we walked the audience through a mock demonstration on campus. So we'd staged it out and then would ask questions. What do you think about it? And these are all lawyers. These are all general counsels from universities and colleges throughout the United States. It was a lot of fun. It was great. And to avoid any real elevation of blood pressure, it was I think it was it was a conflict between the Swifties and Trekkies. So we kept it light, right? So although this can get pretty heated too, I think. Let me just say this, because this is something that is pretty near and dear to my heart as a lawyer, as somebody who cares passionately about higher ed, and as a citizen of this country. The First Amendment is important. It's relevant. And it's been around for a long time. And frankly, it's our strength, in my personal opinion. As Jeff mentioned, governmental entities like yourselves are not without some ability to control that. There are certain things you can't incite violence. You can't create a dangerous situation. You can't break the law. That's not protected by the First Amendment. But hate speech, as Jeff mentioned, hate speech is protected. People can get up and say the most horrible things, the most hateful things. And if they're not inciting a riot or asking somebody to commit violence against someone else, they can do it. That's how that works. And if they get up in public comments and say that for 3 minutes, then our board sits there and listens respectfully, put the timer on, and at the end of the timer, you're done, and that's it. So you have the ability to regulate speech from a time, manner, and place standpoint. You can't allow megaphones around campus right outside classrooms. You can't do that. I'm not in favor of free speech zones, kind of like what you mentioned, Jeff. I think those are fraught with complications. And I consider the entire campus, except for those areas that obviously you can't be in, to be a free speech zone. And so you also always have to keep in mind safety and security. I'm just curious, how many of you here in the room experienced protests at your campus? Okay. Nicole, I think from the community college arena, 50 community college, I don't think any of us experienced anything. I like to think because last year when everything was going on. The second question I was going to ask, how many of you have a policy against encampments? You do. Now? Did you have it last spring? Or did you just develop it?
Our outside counsel administration develop one.
Good. So, and you did it. But what I heard described at the panel I was on this summer was that this was literally like building the plane when you'd already taken off, right? People were looking around for, well, what's the policy against an encampment? Well, don't have one, for overnight stays. I can tell you we have a beautiful campus, Bill, and I could see tents all across. There's something about community college students, though. I mean, I always say this very carefully. Our folks are committed. Our students are committed. The demographic is they want to come on campus, get their job done, and move on. They usually are juggling 2 or 3 other things. But that doesn't mean that free speech doesn't matter. That doesn't mean that our community college doesn't care about free speech. And in fact, what we started at Del Mar College a couple of years ago, some professors put together a free speech day. And again, in January, I'm proud to say that we're going to host a campus-wide free speech day where we're bringing in speakers, trying to educate our community and ourselves more about what free speech is, what the limitations are, and ultimately how we can exercise that right civilly. There's also a Texas law in the books. It's been around since 2019 that the legislature passed that is supposed to ensure free speech on campus, but the First Amendment was already here, and it already did a lot of what the Texas law has attempted to do. So all I would say on that would be to continue to educate yourselves. Like Jeff and Nellie have said, go to your general counsel, go to a lawyer, and find out, before you do anything like trying to shut somebody's speech down, because we won't get into this, but if you'd like to talk about this, is it free speech if it's on social media? If the college's dental department has a Facebook page that's open to the community and somebody gets on and starts putting terrible stuff on there, can you regulate that? Can you shut them down? Can you block them?
So I think
Lots of
that
questions, yeah.
leads into, I'm going to try to get to one hypothetical and then leave a couple minutes for questions. We have 5 minutes left. So First Amendment, we're going to stay in this realm. And First Amendment is one of the strengths of our country, one of many, but a cornerstone of our democratic republic. So here's the hypothetical. You have a fellow board member who is taken to social media criticizing board decisions, blasting you and other members for their positions and votes on agenda items, and has gone as far as hiring a private investigator to investigate you and other board members. So, for this panel, what options does the board have in dealing with this seemingly rogue member? What options exist?
Go ahead, Augie. You know why, right? Because Augie's going to speak from
Hypothetically
experience.
speaking,
Hypothetically.
there's a hypothetical college with a hypothetical
Hypothetical.
board of regents.
There you go.
And I didn't mean to steal all your thunder, Doug, but I was trying to
good.
set up this
Yep.
question,
Yep.
right? And so, again, look, you're public officials, so you've got to have a fairly thick skin. If you don't, then maybe you shouldn't be in this job because it's not about you. And even though people may try to make it about you and will level unfair criticism publicly on social media, in front of a television camera, that kind of comes with the job. You're not a piñata, though, when it comes to having untruthful things said about you. You can always pursue a personal claim for defamation or slander if that's what happens, and but that's you individually. As a public official, you have to be able to tolerate that and put up with it respectfully, and it can be difficult. Now, Doug said the magic word, rogue. So to me, there was a book written by Terry O'Banion, who's a former community college president, who surveyed tons of community college residents across the United States and trustees, and wrote a book called The Rogue Trustee. So when I hear rogue trustee, I'm thinking of a trustee or regent who doesn't play by the rules, who regularly breaks the bylaws, who speaks out of turn, who, despite efforts at counseling and, hey, maybe you shouldn't be doing this, blows it off, comes into campus and interferes with operations. That's what I mean by rogue trustee. What can you do as a board? Well, if you're a community college trustee or regent in Texas, you cannot remove each other. You do not have removal powers yourselves. You are an elected official and you're subject to the Texas law that provides for removal of a public official. That's very difficult to do in Texas. That's very, very difficult to do. In fact, I can't even think of one that didn't involve a crime. So unless there's somebody who, and Doug, unless somebody's breaking the law, it's very difficult to go out and get somebody to, because you have to go through a jury trial. I mean, it's very complicated and all of that. But at the Del Mar College, we have built in a censure provision, censure, censure, not censor. Censor means you cut somebody off from speaking. Censure means that you actually hold a vote as a body and you say, as a body, we do not agree and disavow ourselves from the actions of this particular rogue trustee. And we've had to do it. It's publicly reported. Several years ago at Del Mar College, we had a regent who was like that, and unfortunately, the board had to take the action of censuring that regent. Not once, not twice, but 3 times. And it was for continued, repeated. And you know when it got to the point, I mean, they tolerated a lot. But when we got a letter, when the board got a letter from a local civic group saying, we do not want this board member to come back because they're coming and disrupting and they're saying things about the college, it was at that point that the board felt like it had to step up. And I was there with them. I agree with that 100%. It was almost like they were upholding the integrity of the board. But it's pretty much all you can do is censure.
And that is really a political act. You're not taking any action specifically against that board member. I'm going to throw one caveat into this, and Nellie and Jeff, you want to take this one. What if the board member posts information on social media about information that was discussed in closed session?
I got to tell you, board members have free speech rights too, right? So if a board member decides to post about a topic that was covered in your closed session, well, remember, you might know that we have posting laws, and we post about the items we're going to talk about in closed session. We post saying, oh, we're going to talk about this contract. We're going to talk about an employment matter. We're going to talk about this real estate. So if the board member posts something about, well, we talked about possibly terminating or revoking someone's tenure, well, if it was posted, there wasn't anything wrong with that. I think the real clear answer is going to be a real clear, it depends. It depends on what exactly was posted by the board member and what exactly was in the posting as well, to determine if there is any kind of a violation that's occurred. Because I start out with the premise, you don't give up your free speech just because you now have the title of trustee or regent. You still have free speech rights, but you also have obligations, ethical obligations. Remember the duty of care, loyalty, obedience? That's still there. And so you have to assert your free speech rights in the context of your obligations as a regent and a trustee.
Thank you.
Yeah.
We're at time. Jeff, if you...
Well, I was going to say, I was thinking, well, maybe there's some sort of breach of the attorney-client privilege, but then a client can waive that.
But they're not the client.
They're not the
But, right, so, I mean, I don't,
They're
yeah.
not the client, not individually. Whatever, to what Nellie said, I mean, the last thing I'll say, but is what happens in closed session should stay in closed session. And I think that could be very dangerous. And I frankly think it could lead to criminal action. Again, it depends.
It depends.
It depends. But if it's in closed session, it's there for a reason. It's protected by some kind of legal privilege, and it can get very tricky, particularly if it hurts the institution
Correct.
or if it hurts an individual.
Talk to your lawyer.
Talk to your lawyer.
We're here to help.
We're here to help. And
Yep.
It's always like going. I think Nellie's that it right. It's like if everyone operates within those fiduciary duties, these issues are avoided, right? And so that's the goal: is to work within those, work collectively together for the benefit of the students. Stuff happens sometimes, and speak to your legal counsel when something does, or follow the appropriate channels so you can get with legal counsel. I want to thank this panel for their time and expertise today. Thank you for your attendance.
Thanks.
And I think the next session starts in 15 minutes. Is that right? Thank you.
Thank you. Thank you.